Good evening, everyone, and welcome to our webinar. Medris presents Beyond the Stethoscope in partnership with Fairbridges Wertheim Becker. Our presenter this evening is Natasha Naidoo. Thank you so much for being with us. Just a few housekeeping rules. If everyone can just keep the webinar chat to a minimum. Any questions you have, we will answer at the end of the evening. Feel free to please post in the Q&A section of the webinar. And there will be a recording available after the webinar, so don't fret if something goes wrong and you lose signal. We will make the recording available. So to start our evening off, I'd like to present our presenter for tonight. Natasha Naidoo is a director and heads up the insurance litigation, medical malpractice, and healthcare regulatory team at Fairbridges Wertheim Becker in Johannesburg. She focuses on insurance, litigation, and general liability claims, more specifically medical malpractice and personal injury claims. She advises major pharmaceutical companies and manufacturers of medicine and medical devices in relation to indemnification, class actions, product liability litigation, clinical trials, patient assistance programs, and the like on an ongoing basis. Natasha represents healthcare practitioners in proceedings before regulatory bodies such as the HPCSA, AHPCSA, and the SAPC, and also in civil actions. She has also published a number of articles and presents regularly on a number of healthcare, regulatory, and medico-legal matters. Welcome, Natasha Naidoo. Thank you so much for being here, and we look forward to hearing the presentation. Natasha, your microphone is still muted. If you could just unmute yourself, please.
Can you hear me now?
Yes.
Cool. Thanks very much for the introduction, Kathleen, and a very good evening to everyone who is attending tonight. In dealing with the complaints lodged against practitioners before the various statutory bodies and in civil actions that have been instituted against healthcare practitioners out of high courts over the years, it has become apparent to me that the topic under discussion this evening has been largely misunderstood over the years. And this has led to incorrect practices being implemented, and it tends to go unnoticed until a claim is instituted or a complaint is lodged against the practitioner concerned before the relevant statutory body. So much of my talk this evening will focus on the HPCSA guidelines, and I will also endeavor to clarify a number of issues concerning the duty of healthcare practitioners, and that would relate to their natural duties, moral obligations, institutional duties, legal duties, their duties to colleagues and to themselves. I will also speak to you about what amounts to a breach of the HPCSA ethical and professional rules, and more particularly with reference to Rule 10, which deals with supersession. And supersession is where a practitioner takes over the treatment of a patient from another practitioner without any justification or communication with the treating practitioner. I will also discuss Rule 11, which is dealing with impeding of patients. Impeding occurs when a practitioner informs the patient that the patient cannot obtain a second opinion from another practitioner regarding the diagnosis or the finding that is made or the treatment that is recommended by the treating practitioner. I will then also speak about Rule 12, which deals with casting reflections on colleagues or their abilities and capabilities as practitioners to practice in their area of speciality, and Guideline 6.2, which speaks to working with colleagues with respect. I will also speak to you about a practitioner's duties and obligations in reporting unprofessional, illegal, or unethical conduct to the HPCSA, with particular reference to defamation and loss of income. I will also speak about covering under the HPCSA guidelines, both in the context of locum tenens, and I will also discuss when the duty of care towards patients begin when covering for each other as practitioners. I will provide you with a synopsis of an important case, which actually speaks not only to when the doctor-patient relationship begins, but also the duty of a practitioner who is covering for another practitioner. I will touch on partnerships and sharing of rooms by practitioners and what a practitioner's duty is to themselves. Catherine, if you could change the slide to the next one, please. So in considering what practitioners' natural duties are, like all human beings, practitioners are required to refrain from doing harm and to promote good, be fair and just towards all persons, and that is irrespective of whether they are patients or not. By virtue of the fact that a practitioner is a qualified professional in the field of medicine, practitioners have moral obligations in terms of what they are required to provide, in terms of healthcare treatment, and to treat their patients to the best of their ability, obtain informed consent from patients, respect the patient's confidentiality, and be truthful to their patients and to their colleagues at all times. Next slide, please. Practitioners also have institutional duties, and these are duties that emanate from the practitioner's employment terms and would depend on whether they are in private or state practice, whether they are practicing for themselves privately, whether they're independent contractors who practice out of rooms at a private hospital, or whether they practice in partnership with other practitioners. And the duties conferred upon them are contained in employment contracts and must be consistent with the duties, obligations, and responsibilities that are conferred upon them in terms of the applicable legislation. Very importantly, it must be noted that if there is conflict between a clause contained in a contract of employment and the applicable legislation, which would include acts, regulations, and guidelines like the HPCSA guidelines, then legislation will prevail over the contract of employment. It is very important, therefore, for an attorney to have regard to the contract of employment to ensure that it complies with legislation. Practitioners also have legal duties, and these duties are conferred onto them and emanate from the principles that are entrenched in our Constitution, and by virtue of practitioners being qualified to practice in a particular field of medicine. Practitioners are also required to familiarize themselves with and act in accordance with the legislation, as a failure to do so has potential to expose themselves to medical malpractice claims and complaints being lodged against them, not only by patients, but also by fellow colleagues, or the HPCSA or other statutory bodies with which they are registered. Next slide. This brings me now to what is imperative for purposes of our topic today, that is practitioners' duties towards their colleagues and to themselves. It is important to ensure at all times that practitioners act in the best interest of their patients and the profession, and that they conduct themselves in a respectful and respectable manner in dealing with colleagues, whether it concerns patients or not. And it may come as a surprise, but like any other profession, it is not uncommon for practitioners to badmouth each other. Practitioners should refrain from such conduct and not allow their personal views to dictate their professional views, having regard to the facts and circumstances of each patient's case. For example, if a patient has been referred to you or consults with you to obtain your views regarding treatment that has been prescribed by a colleague, and if you do not agree on the course of treatment prescribed by your colleague, it's important to express your view regarding the treatment you are prescribing with reference to the facts before you. And if you disagree with the treatment that the patient was prescribed by your colleague, you should be able to justify it with reference to facts such as peer-reviewed studies that have been conducted. So in essence, you should not cause the patient to doubt the knowledge or skills of colleagues by making comments about them which you cannot justify. On another note, and just on the issue of impairment, if you have reason to believe that a colleague is impaired in any manner, for example, your colleague is experiencing mental health issues which might affect their ability to treat their patients, you should advise your colleague to seek treatment for their condition, and if necessary, report it to the HPCSA so that your colleague can receive the necessary assistance and guidance. And this would be the responsible thing to do. The practitioner might still be allowed to practice, but on a supervised and monitored basis or on special terms and conditions. And to turn a blind eye could potentially result in issues being encountered by patients and the practitioner concerned. In addition to the duty that is owed to colleagues, it's necessary to always bear in mind that practitioners have a duty towards the profession as a whole. So you are required to report misconduct on the part of colleagues to the relevant statutory body if you have reason to believe that the patient's interests are at stake or a colleague is acting unprofessionally and bringing the profession into disrepute. And I will elaborate on what I've just said above in further detail. Next slide, please. In terms of the HPCSA's ethical and professional rule, that is booklet 2, rule 10, practitioners are prohibited from taking over patients who are in active treatment or who are being actively treated by another practitioner, where the practitioner who is taking over from the patient is fully aware that the patient is being actively treated by another practitioner. So if a patient wishes to be treated by another practitioner, the new practitioner who they approach is required to take reasonable steps to inform the previous practitioner and establish what treatment and medication the patient previously received. A practitioner who attends to a patient as part of a rehabilitative program, for example, post-operatively, is also required to do so in collaboration with the treating practitioner or the practitioner who operated on the patient to the extent that this is necessary. And in this regard, practitioners are obliged to share their notes relating to the patient, of course, with the patient's consent to disclosure of their reports. And in failing to inform the practitioner who is actively treating the patient, a practitioner who is taking over from the patient will be in breach of Rule 10. I'll now move on to Rule 11, which deals with impeding of patients. And what this rule simply provides is that a practitioner cannot impede a patient. And if it is a minor that is involved, then the parent or guardian of such minor cannot be impeded from obtaining the opinion of another practitioner or from being treated by another practitioner. And this would include obtaining of a second opinion on a diagnosis that is handed down by a practitioner, any recommendations on a course of treatment or procedure to be performed, patient management, and any treatment that has already been prescribed to the patient. A practitioner who impedes a patient will therefore be in breach of Rule 11. Next slide, please. 12 provides that a practitioner is not allowed to cast reflections on the probity, professional reputation, or the skill of another practitioner registered under any Health Act. And to do so would result in a breach of Rule 12. Guideline 6.2 requires healthcare practitioners to work with fellow practitioners and to respect other practitioners in the pursuit of the best healthcare possible for all patients. Practitioners are therefore to refrain from speaking ill of colleagues or other healthcare practitioners. They should not say anything that causes the patient to doubt the knowledge or skills of their colleagues by making comments about them that cannot be justified, as I said. So in indicating to patients, for example, that a colleague botched a surgery or that it was performed by a surgeon with inferior skills, or that the surgery was not necessary in the first place, a practitioner will be in breach of both Rule 12 and Guideline 6.2. Next slide, please. As a registered healthcare practitioner, you are obliged to report supersession and other unethical behavior to the HPCSA. But my recommendation would be to address the issue with the offending practitioner concerned by referring to the unethical behavior and requesting that they confirm that they will desist from such behavior. It is also necessary to inform the offending practitioner that should they fail to desist from such behavior, it might then become necessary for you to report them to the HPCSA, and that this would be in your own best interest, that of the patient's best interests, and in the interests of the profession overall. On another note, in terms of HPCSA's Rule 12, which is contained in Booklet 2, a practitioner is required to report impairment of another practitioner if the reporting practitioner is convinced that the other practitioner is impaired. A practitioner is also required to report any unprofessional, illegal, or unethical conduct on the part of another practitioner. What the guidelines actually state is that a student, an intern, or practitioner is allowed to report impairment in another student, intern, or practitioner to the board if they are convinced that the other student, intern, or practitioner is impaired. And they're also required and allowed to report their own impairment, or if they suspect impairment in themselves, to the board concerned, if they are aware that they themselves have an issue, or if they have been publicly informed and perhaps they obtained a diagnosis. And also if they have been seriously advised by a colleague to act appropriately to obtain help as a result of an impairment or a potential impairment. So it goes without saying that patients' interests are of paramount importance. And if any healthcare practitioner has reason to believe that patients are or might be at risk of death or serious harm or injury as a result of colleague's conduct, then that healthcare practitioner has a duty to lodge a complaint against their colleague with the relevant statutory body. Next slide, please. Casting aspirations on a practitioner's character and practice, both with patients as well as with fellow colleagues, in an attempt to justify your own conduct and the treatment provided to patients, is prohibited. This has potential to negatively impact a practitioner's practice and the confidence of patients under the practitioner's care. It may also result in a practitioner suffering direct financial harm and patients refusing to be treated by the practitioner due to false allegations made and rumors being spread about the practitioner concerned. And what might then happen is that it may result in claims for defamation and loss of income being instituted against the practitioner who has made such allegations and is guilty of casting aspirations against a colleague where they are unfounded, untrue, or without any merit. Next slide, please. This slide deals with covering, and a practitioner is allowed to employ a professional assistant or a locum tenens. That's the first thing I just want to discuss briefly, and then move on to the duties of a practitioner who is covering for another practitioner. So as I said, a practitioner is allowed to employ a professional assistant or a locum tenens. And with regards to a locum tenens, such a person in the employ of the practitioner may not be employed for a period exceeding 6 months. And it is also important that the locum tenens is registered to practice in the category of independent practice with the statutory body concerned. And there has been much confusion regarding the employment of locum tenens over the years. And a locum tenens position is one that is held by a practitioner when a practitioner in private practice is going away on holiday or is absent for some reason, such as ill health or whatever the case may be. The appointment of a locum tenens cannot be permanent, and as I said, it cannot exceed 6 months. And for further information regarding the role of a locum tenens and the implications of using this term loosely, I suggest that you read the article by Dr. Natasha Naidoo of Medical Protection Society, or MPS, and I have provided a link to this article as part of my slide. I would now like to tell you about a case. It concerns an issue of covering, and it is important to note the judgment which I referred to earlier, and which was handed down in the case of Life Healthcare Group versus Dr. Suleiman. And the full citation has been provided in my slides if anyone is interested in reading the whole judgment. And I'm also happy to provide you with a copy of the judgment on request. But the case sets out very well the duty of care owed by healthcare practitioners. And it also deals with issues relating to contributory negligence, which is pleaded by one defendant as against the other. And the facts of the case, and I'll try to be as brief as possible, were as follows. An action was instituted by the parents of a minor child, who I would refer to as the plaintiff, against the first defendant, who was the hospital, and the second defendant, who was the covering obstetrician gynecologist, and who was standing in for the treating obstetrician during the latter's absence. And the doctor who was standing in initially denied any negligence on the basis that he was merely covering for the doctor who was responsible for the plaintiff's treatment and care throughout the duration of her pregnancy. The plaintiff was admitted to the hospital around 10:30 on the 12th of July, 2008, and the patient's treating doctor was not available and had handed treatment and care of the patient over to the doctor who was covering for him during his absence. The hospital staff were aware of this arrangement, which is common practice. The nurse on duty called the doctor at 10:30 to inform him that the plaintiff had been admitted to the hospital, and his instructions were to allow the plaintiff's labor to progress. He prescribed Atarax and Pethidine for pain relief and to allow the plaintiff to relax, and also instructed the nurse to sedate the plaintiff if necessary. The nurse on duty then contacted the doctor around 18:35 and informed him that the plaintiff had dilated by 4 centimeters. She reported a late deceleration, which was evident from the CTG, but also said that it had recovered quickly. So at that stage, the doctor instructed the nurse to move the plaintiff to the labor ward, and he ordered that her membranes be ruptured artificially. And at 18:40, the fetal heart rate had dropped to 90 beats per minute, and it was clearly evident that there was fetal distress, as normal fetal heart rate ranges between 110 and 160 beats per minute. But this was not brought to the doctor's attention by the nursing staff. The plaintiff's contractions were becoming stronger, and further late decelerations were recorded, I think one at 19:40, but it wasn't reported to the doctor. He was then informed at 2100 that the plaintiff had fully dilated, and when he arrived at the hospital almost 12 hours later, he attempted to deliver the child naturally. and the vacuum extractor could not be found by the nurse on duty. Further, it became evident when the vacuum was located that the nurse could not use it. Forceps couldn't be located, and all of this just delayed the delivery by a further half hour, I think. So it was determined shortly after the minor had cerebral palsy, and in his defense, the doctor pleaded that he was standing in for the treating doctor and that the plaintiff was not his patient. And he admitted that he had been informed that the plaintiff was handed over to him. It was common practice in the medical fraternity for one doctor to cover or stand in for another when the treating doctor is not available. And he therefore contended that he was on standby for any emergency that would have arisen. So he denied the doctor-patient relationship existed prior to his attendance on the plaintiff at the hospital at 2120. By the time the matter was heard by the trial court, the parties had already entered into settlement agreement, in terms of which the issues relating to liability or the merits of the claim and quantum had been settled between the parties on the basis that the defendants were jointly and severally liable to the plaintiff in the sum of 20 million rands. The offer was made without admission of negligence, breach of contract, or liability on the part of the defendants, and the hospital accepted that its nursing staff had acted negligently. The late decelerations I referred to earlier, which took place, I think, at 1840, should have been reported to the doctor, and he should have been informed that the contractions were getting stronger. The doctor, on the other hand, denied any negligence, and it is on this basis that he said that he had settled the claim without admission of liability. He therefore contended that the hospital was not entitled to any contribution from him, and in the alternative, he claimed for an apportionment in his own favor. The trial court found that the doctor was negligent, but could not find any causal connection between the doctor and the harm suffered by the child or the parents. And in establishing a causal connection, the actions or the omissions of a party are considered in relation to the consequences suffered. So as already said, the hospital conceded liability. The issues which remained in dispute did not involve the patient, as the claim against the plaintiff was settled. So the outstanding issues to be dealt with, and which came on appeal to the Supreme Court of Appeal, were the apportionment of damages, because the doctor denied negligence and pleaded that the hospital was not entitled to a contribution from him. And the hospital sought a contribution from him on the basis that both were jointly and severally liable to the plaintiff, and in saying so, that they were both joint wrongdoers. So in essence, the hospital sought a contribution from him in respect of his responsibility towards the damages caused, and requested that the court grant an order which it deemed just and equitable, and to the degree in which the doctor was at fault. I won't go into apportionment of damages in great detail, but the more important point for purposes of our topic was the duty of care owed by the doctor. And in dealing with the issue of whether or not the doctor owed a duty of care to the plaintiff, the SCA held that it was clear that the legal duty was established when the doctor had agreed to cover for the treating doctor who was not available. And furthermore, when he received the first call from the nurse at 10:30, informing him of the plaintiff's admission to the hospital. So the doctor's legal duty was furthermore, it was also confirmed when he gave telephonic instructions to the nurse to administer the atarax and pethidine, and to furthermore allow the labor to progress in the ordinary course, and to sedate the plaintiff if necessary. And the duties of the nursing staff were set out quite clearly. That is, their duties include monitoring, observing, and recording the developments, the progress or the lack of progress of the patient's labor. The nursing staff didn't inform the doctor of the late deceleration, which was evident from the CTG, and it was not communicated to him that the contractions had become stronger. But with reference to the breach of duty on the part of the doctor, the court stated that in considering whether he acted as a reasonable obstetrician gynecologist would have acted in the circumstances, the reasonable obstetrician gynecologist would have attended on the plaintiff shortly after the patient's admission to the hospital. Further, the court held that the doctor was aware that the plaintiff had not been attended on by her treating doctor, and he also failed to call her telephonically to inform her that he would attend on her. So the SCA held that a failure or an omission of this nature amounted to gross negligence. And this was more so in light of the fact that the doctor stated that he did not regard the plaintiff as his patient. The court held that the doctor's negligence was the cause of the minor's cerebral palsy, and the doctor attracted great criticism by virtue of the fact that at 1840, at which stage the adverse finding on CTG was noted, he had still not attended on the plaintiff in hospital, and that his response simply was that she was not his patient. He was criticized further for arriving at the hospital only at 9:30 for the first time since the plaintiff had been admitted to the hospital. And in arriving at this decision, the SCA stated that the question the trial court should have asked was it more probable than not that the birth injuries suffered could have been avoided if the second defendant, that is the doctor, attended on the plaintiff earlier? And what it emphasized is that the nursing staff is there to observe whether while the doctor is responsible for diagnosis and ordering of treatment. And the real question that needs to be asked is not whether the doctor's earlier attendance on the plaintiff would have avoided the harm suffered by the minor, but rather whether he had an obligation towards the plaintiff to attend on her earlier in circumstances where he could have performed an emergency C-section. So the hospital succeeded on appeal in proving factual causation on a balance of probabilities. Next slide, please. I now move on from the case study to something different, which is a subtopic, and I will touch briefly on it. It deals with partnerships and sharing of rooms. I'm not going to delve into the requirements for establishment of a private practice or a partnership, safe to address this issue in the context of our topic tonight. So practitioners are allowed to practice as part of a partnership, an association, or to employ practitioners who are registered in terms of the relevant legislation. And in the case of employment, the practitioner who is being employed would need to practice in the same practice area of expertise or play a supportive role, in terms of which the employing practitioner's practice is supplemented in providing treatment to patients. So a practitioner is not allowed to share their rooms with anyone who is not registered in terms of the applicable legislation. Next slide, please. It is important for a practitioner to maintain and improve their performance as a practitioner. Increasing their knowledge and sharpening their skills is not just in their areas of specialty, but also in relation to ethics, human rights, and health law. And this can be done by partaking in educational activities that are aimed at enhancing the services provided, and also maintaining the practice from an administrative perspective. It is just as important for practitioners to familiarize themselves with the legislation, which includes the acts, the regulations and guidelines, and also any developments in the law. Practitioners should also refrain from engaging in activities that might affect their health and lead to impairment. And staff members, including administrative staff, should be trained to respect patients' rights in particular, the right to confidentiality, patient billing, and the like. Patient record keeping is important as it is key in leading evidence in the event of there being a claim against the practitioner. And to this end, we offer workshops on practice management as well as practice record keeping, which it can be very informative to not only the healthcare practitioners in the practice, but also the admin staff. And that brings me to the end of my talk this evening. I hope that it was informative, and I'm happy to take any questions now.
Thank you very much, Natasha. It was absolutely wonderful, very informative. We do have one or two questions in the Q&A section. So perhaps I'll just start off with the first one. Somebody says, good evening. Thank you for the meeting. If there's a breakdown of the patient-doctor relationship and the current doctor feels he or she can no longer see the patient, for example, the patient is rude and has unrealistic expectation, is the current doctor's duty to find a doctor to take over management of the patient, or is writing a referral letter containing the relevant information suitable?
Well, as a treating doctor, you can most definitely recuse yourself or decline to treat the patient further, provided that the patient is in a stable condition and, it's not an emergency case, and refer the patient to a colleague, to another healthcare practitioner. It's not entirely necessary for you to find a doctor that is suitable to take over the management of the patient. Providing a referral letter containing the relevant information, as you say, is suitable. And furthermore, liaising with the new doctor regarding the patient's, the treatment that has been provided to the patient already is also required. Of course, you'd have to obtain the patient's consent to divulge that information to the new healthcare practitioner.
Okay, great. Another one says, as a doctor in a solo practice, what are my duties regarding coverage of my own patients after hours for emergencies when I am not on call? Due to the severe shortage of specialists in my field, it's not possible to provide 24/7 coverage on a daily basis.
So I'm assuming that you are in private practice. Generally, it is said that a healthcare practitioner is supposed to act reasonably in the circumstances, and the circumstances would refer to what resources you have available. Of course, in state practice, where there is a lack of resources, it is not the making of the healthcare practitioner if there's a shortage of doctors and things like that. But it is important, if you are in private practice, that somebody is on standby for emergencies when you are not on call. And this is notwithstanding the fact that there is a shortage of specialists in your field. Yes, there are certain areas of speciality where there might be 5 or 6 specialists in the country. But obviously you would have to brief a colleague who is able to attend to the patient to the extent that it is necessary in your absence, even though the patient or the colleague may not have the same level or degree of expertise as you do.
Okay, perfect. I don't see any more in the Q&A. Perhaps we can just have a look at the chat itself. I do see one question. It says, there are rumors that doctors can now be employed by companies and or non-medical individuals. Is this true?
Doctors cannot be employed by hospitals. And this is in terms of the National Health Act. I have not seen, or I have not read any of these rumors about doctors being able to be employed by companies who are not in the, healthcare industry. I haven't seen that, but I can tell you that doctors cannot be employed by hospitals. They can act as independent contractors, practicing out of rooms at a hospital. So they are still required to have their own professional indemnity insurance, and there ideally should be a independent contractors agreement, just to cover any gaps between the healthcare practitioner and the hospital. That is to avoid allegations of vicarious liability, where the hospital is held liable for the acts of its employees, and where it is assumed that the doctor is an employee of the hospital. But no, I have not heard of these rumors, and I have not seen anything in this regard.
Okay. We do have a couple people that have raised their hands. If I can just ask any of the attendees who do have a question, please put it in the Q&A section so we can attend to it.
Kathleen, while we are waiting for further questions, maybe I can just ask Natasha one or two questions. So you mentioned earlier about, when a doctor spread rumors about another doctor and there's an income protection claim. Right? So
Yes.
a doctor, this causes a loss of income. And I probably know this answer, but maybe it's nice for the audience to hear this from you. Just in terms of their malpractice insurance policy. So, for example, Dr. X is covered with an insurance provider, and he spread rumors about Dr. Z. Now, Dr. Z is a loss of income, and there's a HPCSA complaint against our doctor, regarding loss of income. Would that doctor's insurance cover pick up that particular claim?
So it wouldn't be an HPCSA complaint against the doctor. It would be a civil action instituted against the doctor, in terms of which there is a claim for loss of income. And no, unless it expressly states that it would cover such damages, the policy would not cover it.
Thank you. And then maybe just one more of a comment. Just in terms of, very often we notice, for example, I came across a claim maybe about a year ago. Wasn't a claim for one of my doctors, where there were two treating practitioners. There was some friction at the hospital between a neurosurgeon and a spinal surgeon. And what happened is both doctors claimed it wasn't their patient. The one said they handed over the patient, the other one denied that. But in terms of notes, what I do pick up, sometimes when there are more than one treating practitioner, the doctors don't take notes of the conversations between each other. Maybe just some comments on that.
Yes, so that is a big problem, especially as you say, where there's a multidisciplinary team of doctors that are treating a patient. I mean, it's very common that, oncologist and a radiologist and, a pathologist, a whole team is treating a patient, for example, who is suffering from cancer. But that is where record keeping is pivotal. It is extremely important, even if it is a sudden emergency situation where the patient needs to be intubated, obviously you've got to see to the patient and deal with what is important at that time. But retrospective notes can be made, and it is very important to note this in the records, especially when the courts want to establish when the doctor-patient relationship began. And it's important to do proper handover if you are handing over to a doctor who is covering for you in your absence, for example. Good bedside manners require that you've got to do it in front of the patient, in the presence possibly of the patient's family and other healthcare, like the nursing staff, and that it must be recorded. So you know, it's while it happens and while, you know, it might not pose a problem until somebody raises a problem or claims or, you know, lodges a complaint with the HPCSA. It's okay to do it telephonically, but the correct way to do it is to do it in person at the patient's bedside, and to note it all in the records.
Okay, thank you, Natasha. We do have a couple questions. The first one being, what is the stance of allied professionals being employed by hospitals? So that's in relation to your previous comment to a question about healthcare professionals being employed by hospitals. So for example, a radiographer, an allied professional, what is that stance?
So a hospital cannot own a pathology laboratory or a diagnostic center. It is usually a separate entity that is within the hospital and operating from the hospital. So you will find that it's, you know, it trades under its own name because hospitals are not allowed to employ healthcare professionals. So it is not the hospital itself who has employed the radiographers, but an entity which is affiliated with the hospital.
Okay. Jamal, do you want to take the next one?
Yes. So the next question, regarding the Suleiman case which you referred to earlier, if the treating gynae was a locum, would the gynae who saw the patient initially be at fault, along with the gynae who assisted with the birth, and how would that case have been handled?
So yes, if the doctor who was standing in was a locum, then the employing doctor would be vicariously liable for the acts of the locum, which would be imputed to him by virtue of the employment relationship. And, you know, these acts were obviously committed during the course and scope of his employment. So yes, it would have had a different outcome in that the employing doctor would have been joined to the proceedings as a party or a defendant. And that is why it's also important not to use the term locum tenens loosely, because it can imply that somebody is employed by you as a locum tenens, whereas they are, you know, I mean, as a permanent employee, whereas they are a locum tenens, or vice versa.
Okay. Now, the next question we got here, patients are often seen at night by a trauma doctor who calls the specialist for advice and then admitted overnight and seen by the specialist the next day. Is this acceptable?
Well, the moment you accept a patient as your patient, it is your duty to attend on the patient in hospital. If you've been informed that a certain patient has been admitted from trauma to ICU or whatever ward, high care, it is your duty to attend on the patient. Yes, doctors do call in the nurses to find out if the patient is in a stable condition. But it is important, depending on the circumstances, for the doctor to see the patient as soon as possible. I had a case, for example, where the patient was admitted and he had pneumonia, and as a precautionary measure, he was put into ICU. And you know, things progressed overnight so rapidly. And by the time the doctor arrived the next morning at 7:15, so he had been admitted at 6 p.m. that evening, at 10:30 that night, he was still fine. And by 7:10 the next morning, he had died because he needed to be intubated overnight, and the doctor was not available to come in to do that, and nobody could be found to come in and assist with that. So yes, it is important to see the patient as soon as possible, but you obviously have to have regard to, you know, whether it is, you know, what is wrong with the patient, the facts and the circumstances surrounding this particular patient.
Okay. Another question is, as a pre-hospital healthcare practitioner and owner of a private ambulance emergency service, can a doctor at an emergency facility or hospital turn down a P1 patient if the hospital emergency is full or no beds are available?
Sorry, I'm just reading the question. Well, there shouldn't only be one emergency facility available. There should be an alternative available in the event of the one that is used consistently not having capacity to take on any patients. But the hospital would obviously need to make arrangements for the patient to be transferred to a facility where there are beds available. And obviously look at the patients who are currently in the emergency room at the hospital, and look at whether they need to be there or they need to be transferred, and for provision to be made for a patient who needs treatment, more importantly, to be taken into the emergency center.
Thank you, Natasha. The next question, maybe it's not directly related to this, but I'll just ask it. Is it legal, ethical for a group of specialists to use only a specific lab for all the patient blood tests, and in fact have a phlebotomist in their rooms from that lab?
Well, you tend to find that certain specialists will refer patients to a particular laboratory, and it is not uncommon. There are only so many laboratories in the country, but having somebody from that lab in their rooms, that is of course odd. But obviously, if there is any complaint to be made regarding kickbacks or perverse incentives and things like that, then you'd have to have the relevant evidence to justify such allegations. And that shouldn't come only from doctors or colleagues, but also from patients.
Okay. The next question: what happens if you were employed by a doctor, however, he was using another doctor to claim from the medical aid on his behalf due to the fact that he was suspended by the HPCSA? I mean, I think it is unethical behavior, but you can maybe answer that
Yes, I
question.
mean, as a start, he shouldn't be in practice. And that's basically the long and the short of answer to that question. He shouldn't be in practice. He definitely shouldn't. And, the doctor who obviously has sort of employed him under the guise of, that the claims are being put in by his practice is at great risk himself. So nobody should employ a healthcare practitioner who has been suspended, because that is prohibited in terms of the legislation.
Thank you, Natasha. So the last question I have here is, I've been requested to cover a surgeon. Then I realize that colleagues do harm for his patients. I'm actually a bit confused. I don't understand the question. However, that he covers himself very well with the patient's family. So what's my responsibility, legal and ethical point of view in this case? I don't know if you understand the question, but I'm struggling to make out what the person is asking. Maybe I can move on to the last question.
Okay.
Okay. If the trauma doctor discusses a patient with me at night that is not on medical aid, can I give clinical advice as a specialist to the trauma doctor and ask the trauma doctor to transfer the patient to a state facility, as the costs in a private hospital will escalate and everyone into an inconvenience, including the patient. And then the
Yes.
same person asks, do you have to come out to assess the patient? So maybe it's a two-part question from the same person.
Yes. So I did have a case like this as well, where there was a complaint against a gynecologist with the HPCSA, and he saw to the patient, and the patient was treated as a private patient. And when they realized that the patient would have to undergo a C-section, he said to her, okay, you don't have the funds and you're not going to be able to pay for the treatment in hospital and the costs of operations and things. He then suggested that she be transferred to a public hospital, a state facility. And the good thing about this is that he made notes about it in the records, had discussions with her and the family. So yes, you can actually give advice to another healthcare practitioner regarding a patient who is not on medical aid. I mean, that emanates from your duty as a healthcare practitioner, to provide that advice where it is sought of you, and suggest that the patient be transferred to a state facility due to the cost implications. And yes, very importantly, do make notes of this, because it can always come back to bite you. And do you have to come out to assess the patient? If necessary, yes, you would have to come out to assess the patient, as was the case in the matter which I just told you about.
Thank you, Natasha. This is the third time I'm saying last question, but this is the last question. And if anybody types anything else, we can always try and get them afterwards. So, Carte Blanche recently ran a piece on the surgeon. Are you familiar with this? And if so, are you in a position to make a general comment on this? HPCSA clearly cleared this doctor. If you're not familiar with it, it is okay. So one of my doctors, I'm assuming I know who put this comment. He was involved in this case as well. Do you have any comments on that particular case?
No, I don't have any comments on this case.
Okay, then that's it for now. So thank you, Natasha. It was a very thoughtful presentation. I can see you put a lot of effort into it, and it actually showed. I've got numerous comments here. Excellent presentation, great presentation, very informative. So thanks, Natasha, and hopefully we'll get you soon to talk to our clients and other attendees as well. And to the attendees, thanks. Besides your CBD points, your ethics points that I know it's in high demand, hopefully you actually learn something from the presentation and you can take something back to your practice to make it not completely risk-free, but at least eliminate some of the risk which you otherwise would have been exposed to. And then lastly, I would like to thank my team at Medrisk, Kathleen, and the rest of the team. There was quite a bit of work in putting this presentation together, and we really appreciate it. And sorry, I realized I never introduced myself. I am the Jamal Ismail, the CEO of Medrisk. So now everybody, in fact, my name is on the screen. But thank you everybody for attending. You can enjoy your evening now. Take care.
Thanks very much, Jamal. And if anybody has any other questions, they are welcome to contact me. You can give them my email address and I'd be happy to address any of their questions. Thank you for the opportunity and thank you to everybody for attending.